Hey everyone, this is Thomas Edwards with CCH. We're just going to be waiting a couple of minutes for a few more folks to join, and then we'll kick this off. Hi all, we're gonna wait about 2 more minutes to get started. Thank you all for your patience. All right, everybody, we can get started now. My name is Thomas Edwards. I am a family law attorney with the Chicago Coalition for the Homeless. I've been working with CCH for about 2 years, and my pronouns are he, him. I'm really excited for everyone to be here today for our training on student homelessness, family law, and public benefits for immigrant families during and post-pandemic. I think this is a really timely training, and I thank you all so much for being on today. Before my colleague introduces herself, I just wanted to let everyone know that you can put your questions in the chat, whether you're on Zoom, YouTube, or Instagram Live, and we'll be able to monitor the chats throughout. We'll have a time for questions at the very end, so please be patient for us to answer your questions if we don't respond immediately. Also, if you're an attorney and you're planning to get MCLE credit, we'll be sending a survey out after the training today. So I'm going to kick it off to Alyssa.
Thanks, Thomas. Hi, everyone. My name is Alyssa. I am an education attorney at the Chicago Coalition for the Homeless. My pronouns are she and hers, and I have been doing this work for about 6 years, and am really excited to give this presentation. So, Sue, if you could switch the first slide. So I wanted to start by giving a little information about the Law Project. So the Law Project is part of the Chicago Coalition for the Homeless. It was founded in 1997 and has a youth futures mobile legal clinic that launched in 2004. The Law Project provides a wide variety of services, including civil and some limited criminal legal services to families and youth experiencing homelessness throughout the Chicagoland area. So today's presentation, as we mentioned, we're going to talk about educational rights, public benefits, and family law matters as they pertain to newly arriving migrant families. So as I'm sure most of you are aware, over the past year, Illinois has received many newly arriving migrant families from buses from Texas. These families came from around the world, and Chicago and Illinois were not necessarily prepared to provide these services. So our hope with this presentation is to give a little information about rights and resources that are available. Many of these families have been staying at police stations or various temporary shelters because there hasn't been capacity to really provide truly adequate shelter for their families. Chicago and the surrounding suburbs have had challenges providing the needed shelter and other resources to families, especially when it comes to providing access to school. Students who are newly arriving and staying in any form of temporary living situation, which is the vast majority, has a right to immediately enroll in school. So I'm going to be providing some more details on what the law says and how we can advocate to make sure that students are accessing school and provided the rights that are given to them. So the Illinois State Board of Education reported that in total, the public schools identified over 47,000 homeless students during the 2022 school year. And this isn't necessarily taking into account every family who was newly arriving. And just a comparison for how many students this really is, the current seating capacity for Wrigley Field is around 41,000. So this is a big number of students, and we believe that this is actually an undercount. And the reason being is that it can be really challenging to identify students. And if students are not being connected to schools, those students aren't going to be counted. It's also hard when families don't know about their rights or when employees of schools don't know and are therefore unable to communicate that to families to get properly identified and connected to resources. So Chicago Public Schools in the 2022-2023 school year identified over 17,000 students who were experiencing homelessness. So now we're going to talk about some state and federal law that protects the rights of homeless students. And this information pertains to students who fit the definition of who qualifies as someone experiencing homelessness. And that is also going to include many families who are newly arriving. So the purpose of state and federal law, and specifically what we're talking about is the McKinney-Vento Homeless Assistance Act, is to ensure that each child of a homeless individual and each homeless youth has the same equal access to free, appropriate public education, and to eliminate barriers to the identification of or the enrollment, attendance, or success in school of homeless children. So what this means is there are specifically laid out provisions in the state and federal law to protect the rights of students. But if something is not specifically laid out, if something happens, like all of a sudden Illinois has all these newly arriving families, or our world goes through a global pandemic that the law doesn't specifically talk about, we always go back to this, that the purpose of the law is to ensure that each child has equal access to school, and that barriers to identification, enrollment, and attendance in school are removed. So here's a list of the federal law, which is the McKinney-Vento Homeless Assistance Act, the state law. So in Illinois, we have the Illinois Education for Homeless Children Act, the Illinois Equal Opportunity Regulations. There's also the Chicago Public Schools Policy Manual in the specific portion, which is about the education of homeless children and youth. There's also policies that are by the Illinois State Board of Education, as well as non-regulatory guidance from the Illinois State Board of Education that talk about the rights of students experiencing homelessness. So, wanted to start with the definition because the McKinney-Vento Homeless Assistance Act has a broader definition of who counts as experiencing homelessness than other federal laws do. So this is different than the HUD, Housing and Urban Development definition, because it encompasses more families. So there's kind of two ways to look at this definition. So the first is that it gives specific examples of who counts as someone experiencing homelessness, and I'll go through those. Then it also gives a broader way to say those who lack a fixed, regular, and adequate nighttime residence. So we know that every family situation is different and that there's always nuanced things that are occurring. So even if a family doesn't fit into one of these specific categories, if the housing is lacking a fixed, regular, and adequate nighttime residence, they could still be considered McKinney-Vento, which is why it's so important to ask respectful and thoughtful questions to figure out what's really going on with the family to make sure that the students are connected and identified. So first, it includes those living in emergency or transitional shelters. And maybe this is what we kind of typically think of as a family experiencing homelessness. But it also includes sharing the housing of other persons due to loss of housing, economic hardship, or a similar reason. Now, I bold this because this is disproportionately how families experience homelessness here. So the majority of families are not going to necessarily be accessing the shelter system. They're going to be staying with friends or relatives. And while I think we sometimes have this idea that that doesn't count, when you actually look at data and statistics, families who are living doubled up encounter a lot of vulnerabilities. They have no legal rights to stay where they are. Sometimes it's overcrowded. Sometimes it's an unsafe situation. And so the law is there to support those students whose housing is very transitory and can make it really hard to otherwise access school. So it also counts those abandoned in hospitals, living in motels, hotels, trailer parks, camping grounds, due to the lack of alternative adequate accommodations. It also includes a primary nighttime residence not designed for or ordinarily used as a regular sleeping accommodation for human beings. So I think, if we're having families who are staying at police stations, that seems like that would fit under there because that's not a place we would typically think of someone to be sleeping at. Living in cars, parks, public spaces, abandoned buildings, substandard housing. And I want to highlight that because sometimes someone could say that they technically, have a home or are renting. But when you look more at what's actually going on, it's not really adequate housing. Maybe there's not running water. There's, electrical wires that are out. There's 10 people staying in, a one-bedroom apartment. That's why it's really important to ask those sensitive questions to figure out what's going on. And then migratory children and refugees who are in any of the above situations. So what this means is the vast majority of newly arriving families are going to meet this definition of STLS, which is the Students in Temporary Living Situation programs and how Chicago Public Schools supports students experiencing homelessness. So the vast majority are going to meet this definition and therefore should be enrolled under the McKinney-Vento Act as a student in a temporary living situation. So I also wanted to specify that the law talks about unaccompanied youth. Now, we use the word unaccompanied youth, but there's not an age limit when we're talking about this. So it could be a young child, it could be a teenager, but it's a child or youth who is not in the physical custody of a parent or guardian. And that physical custody is what really matters. So if a child technically, has a parent who still has custody or a guardian who has custody, but they're not staying with them, they can count under this definition. And Chicago Public Schools identified over 1,600 unaccompanied homeless youth. So every public school district, is going to have a form of a McKinney-Vento liaison. Here in Chicago, every public school in Chicago, and then every public school district in Illinois has a designated liaison who assists homeless children and youth with enrollment in school and resources to attend and succeed in school. So in Chicago, these are typically called STLS liaisons or STLS advocates. And liaisons and school staff play a very, very crucial role in sensitively identifying students experiencing homelessness and connecting them to needed resources. So I'm now going to talk about some of the key and important rights that are provided under McKinney-Vento. So homeless students have the right to be immediately enrolled in school, even if they've missed application or enrollment deadlines during any period of homelessness, or if they don't have records that are typically required for enrollment, such as previous academic records, medical records, proof of residency, or other documents such as a birth certificate. So what this means is that if a family comes into a school and they express that they are experiencing homelessness or housing insecurity, or if, based on other factors, the liaison at the school determines that, there might be something going on with their housing situation, that student needs to be immediately enrolled. And that really does mean immediate. It does not mean in a week. The student should be filling out those forms with their parent or their guardian that day when they come into the school. A plan should be in place that day. If the school should not turn away enrollment because they don't know where to place the child. So when you think of records or transcripts, let's say we have a newly arriving family who they don't have access to their previous academic records, that child should still be enrolled and be placed in what seems to be the most appropriate class. And then the school should work with that student, with that family, to figure out if, that is indeed, in fact, the correct class. But there shouldn't be delays in enrollment because of that. And enrollment is defined as attending classes and participating fully in school activities. So the school shouldn't enroll the child, but then, tell them that they need to stay home or wait until they get the records. They need to enroll them. They need to be attending classes, especially when we think of newly arriving students who have probably had their education disrupted, who have been very transient and probably haven't had consistency in school. It is so important that we try to minimize the amount of days that they are out of school. And the law requires it. So there really should be a big effort. And it is required by law that these students are enrolled in classes. And if something happens that they need to be switched into a different class, that's okay. But we don't want students to continue to miss school. So for unaccompanied youth, they do not need an adult to enroll in school. Adults don't need to show proof of guardianship to enroll a child or youth. And immediate still means now. So, I think when we're thinking through newly arriving families, if there are children, youth who did not come over with their parent and are maybe staying with a relative, an aunt, an uncle, with grandma, but that person does not actually have legal guardianship, that's okay. They can still enroll that student, or that student can still enroll even without an adult. They should not be turned away from school just because they don't have someone who doesn't have guardianship, and the school should not be giving legal advice to families. So a school should not be telling a family or telling anyone that they should go out and get guardianship. The school needs to have a method, have a plan to enroll that student, make sure they're getting in school and connected with the resources they need. And the burden is on the enrolling school to contact and obtain other records. So they should enroll the student and then be working to figure out what classes, that student has already taken. And again, enrollment means full participation in all classes and school activities. So school districts also have a, affirmative duty to remove barriers. So if there are barriers for partial or incomplete coursework and credit, the school should really be working with that student to accept that partial coursework, to accept the credits that they have so that that student can graduate as close to time and not put additional burdens for a student who's already been through so much. Schools should also have specific outreach to seniors experiencing homelessness to make sure they're on track to graduate and to help them figure out the resources available to allow them to access college. So there are specific kind of choices of school for students experiencing homelessness. So we kind of break it down into 3 different types of schools. So a homeless child has a right to immediately enroll in their school of origin and the local attendance area school. So the reason we say there's 3 kind of schools they can go to is school of origin, we break down into 2 different types. So this can be the school the youth or child was last enrolled. So whatever school they were last enrolled in, and this can include a designated receiving school at the next grade level for all feeder schools. So preschools can be considered a feeder school for kindergarten. The school, and then it can also be the school attended when the child was last permanently housed. So the reason we break these 2 definitions up is it can be the same school, but it also can be a different school. The school they were last enrolled in could be a different school than the school when the child was last permanently housed. The child also has a right to attend the attendance area school that non-homeless children who live in the same attendance area are eligible to attend. So let's say a family who is newly arriving is staying at a police station. If there is, the local attendance area school for that neighborhood, they would have a right to go there. They would also have a right to stay at the school of origin or whatever school their children was enrolled before that. And that choice is up to the family. School districts also have, and states have, an affirmative duty to remove barriers to option schools. So states have procedures that ensure homeless students who meet eligibility criteria don't face barriers to accessing academic and extracurricular activities, including magnet school, summer school, career and technical education, advanced placement, online learning, and charter school programs. And I think where this becomes relevant is for newly arriving families, they maybe missed a deadline to apply to option schools. And that shouldn't create a barrier. So schools and districts should be working with families whose students, would otherwise meet those eligibility criteria for placement options, even if they missed deadlines to apply. There also should be barriers removed for preschool. So state plans need to include procedures that ensure homeless children have access to public preschool programs. And I think this is particularly important for newly arriving families because of resources that can be available at preschools. And liaisons should ensure that homeless families and children can access early intervention services if eligible. And as mentioned before, the definition of school of origin can include preschools. So transportation services. So transportation services are available to homeless students attending their school of origin. So if a family was staying, at a shelter, at a police station in, Aurora, and they get moved to a shelter in Chicago, they still have a right to attend that school in Aurora, and that transportation is provided by the school district. This extends to and from school and includes transportation for school-related activities continuously through the end of the academic year in which permanently housed. So let's say a family is staying at a shelter, In August, they are enrolled as a McKinney-Vento eligible family. They're given transportation. And then let's say in March, the family secures housing. They continue to get that transportation till the end of the school year. Transportation also needs to be provided if lack of transportation is a barrier to attendance, enrollment, and success in school. So even if a family is attending their local attendance area school, but let's say that their local attendance area school is a mile and a half away, crosses a busy street, the family, because of mobility issues, cannot get there, because of a job schedule, can't get there. Transportation then also needs to be provided if that is a barrier, even if the family is attending their local attendance area school. The transportation method needs to be appropriate and not create a barrier to enrollment, attendance, or success in school. So school districts have flexibility to determine the type of transportation that makes the most sense in their area. But it needs to be appropriate. So this can be reimbursing families, gas cards, school buses, public transportation, and taxis. So in CPS, they give bus cards, venture cards to families. If a family is enrolled in STLS, they can also qualify for hardship transportation, which is a bus that's, door to door. In suburban areas, there might not be access to public transportation, so it might be gas cards or reimbursing the families. If the distance is really long, it might need to be a taxi. So it's really on the school district to figure out what makes the most sense. But that method needs to not create additional barriers for families to access school. And I see there's a question about transportation. So I know we're going to answer them at the end more, but because it makes sense. So it was around if suburban areas are also impacted by this. And yes, so there are suburban school districts that have also been impacted by the migrant housing situation. And there's been a lot of change because, there's been temporary shelters set up in various places and families have, been moved as new shelters are opening up. So this isn't just about Chicago. All of Illinois has been impacted by newly arriving families. And all school districts should be, aware. I think all liaisons should be aware of, what resources they need for these newly arriving families. So, as I mentioned, again, for CPS, they have hardship transportation available for families. So if a parent is unable to accompany his or her child on public transportation to their school of origin due to a hardship, the parent and or unaccompanied youth can apply for hardship transportation services. So this is a common question I get a lot is how long can a student be considered homeless? And I think school districts ask this a lot. So there is nothing in the Chicago Public Policy Manual, in Illinois state or federal, in Illinois law or federal law that limits the time a child may be considered homeless. There is no time limit because homelessness is extremely hard and getting housing is extremely hard. And there's so many factors that go into what prevents someone from getting stable housing. The Illinois Education for Homeless Children Act does give school districts the option to conduct a review of eligibility in cases where a child is doubled up at the same location for more than 18 months. So a school does not have to do this, but they are allowed to do a review to determine if the student's still eligible. But that is not a timeline. So families can most definitely be considered McKinney-Vento eligible, be considered homeless for more than 18 months. That's just when a family can review the facts, or when a school district can review the facts. So I wanted to talk about school fees. So almost all Illinois school districts charge students annual mandatory fees. But for students experiencing homelessness, they can be waived, and for students who are economically eligible. So the way the Illinois school states it is that fees must be waived for all students whose parents are unable to afford them, including but not limited to students eligible for free breakfast or lunch. Students experiencing homelessness are categorically eligible for free breakfast and lunch, and so therefore categorically eligible to have their school fees waived. And the administrative code talks about which fees get waived. This includes things that are kind of mandatory for accessing school. So school records, health service fees, required textbooks and instructional materials, charges and deposits collected by a school for use of school property, charges for field trips that are made during school hours or made after school hours if the field trip is required or a customary part of a class or extracurricular activity. Also includes like charges or deposits for uniforms, equipment related to varsity or intramural sports or fine arts, charges to participate in extracurricular activities, graduation fees, and graduation caps. And students cannot be denied access to graduation just because of fees. That's something we see every year. And that should not be the case. Students should not be told they can't access graduation, they cannot walk just because they have unpaid fees. Charges for school supplies required for a particular class, driver's education fees. And there's been a recent change in Illinois law so that students experiencing homelessness can also receive a waiver for school fines, and that transcripts cannot be withheld just because a family can't pay fees if they the fees for the school. And school fee waivers also count for those who cannot economically qualify for charter schools as well. So any student who is eligible for free breakfast and lunch and meets those federal eligibility guidelines, whether they're at a traditional public school or a charter school, should have their school fees waived. ISBE does talk about which fees do not get waived, and these are kind of things that are considered optional. So athletic events, admission to school dances, library fines, charges for the purchase of class rings, additional travel taken, some ordinary supplies, even though the liaison should work with students and help them if they are in need of those supplies. No discrimination or punishment of any kind, including lowering of grades, exclusion from classes, can be exercised against a student whose parents or guardians are unable to purchase required textbooks or instructional materials or to pay required fees. So, things like school dances are not technically waived, but we would say that it is a type of punishment if a student is told that they cannot access prom or buy a school dance ticket just because they cannot pay fees. So I also wanted to briefly talk about what if there is a disagreement. So McKinney-Vento specifies what must happen if there is a dispute. So if the school district doesn't believe the family for whatever reason, if something is going on, or if the family believes that their rights are not being upheld, a McKinney-Vento dispute resolution process can be held. What's most important is that even if a student or even if the school district wants to bring a dispute against a student, the student needs to be immediately enrolled in school and transported to school until the final resolution of the dispute. So they cannot tell the child they cannot stay in school just because of the dispute. If there is a dispute, the school district's homeless liaison needs to become involved. The school district needs to explain it to the family. The school district's responsible for facilitating access to legal help and advocacy, as well as other information to families. And a letter should be provided to the family that explains exactly what the dispute is about. And it needs to be provided in a language that is accessible and clear to the family. And again, the law provides that students who are homeless need to be immediately enrolled and transported to school. The parent or guardian or unaccompanied youth seeks enrollment in until final resolution of the dispute. Families and students are entitled to a full and fair hearing in front of an ombudsman. The ombudsman needs to make every effort to convene the dispute within 10 school days of his or her appointment. The parent has a right to representation at the hearing, and they also have a right after to appeal this. As I mentioned, this hearing can be about transportation, fee waivers, eligibility, school of origin enrollment, access to services, and families are entitled to bring up a dispute as well. So if they feel like their rights are not being accepted by the school. And just a couple tips. So making sure that student records are included so that there is a complete understanding of what's going on. Always making sure that the school has provided to the family exactly what the situation is and explain it to them so that everyone is clear on what is happening. Important documents need to be looked at, like evictions and foreclosures notices. Having as much information about the situation as possible is always helpful. And now I will pass it off to Thomas, who's going to talk about family law.
Hey everyone, thank you so much, Alyssa, and everyone for staying on. As I mentioned earlier, please add comments in the chat. I know there's been a couple, but we will get to those after we are finished with the presentation, just to make sure we can get through all of our material and answer your questions afterwards. So again, like I said, my name is Thomas. I am a family attorney and I work with domestic relations, child welfare, domestic violence, and public benefits. So I put child welfare because I think that is something twice, I guess, because I think that's something that a lot of folks have questions about. So I'm excited to jump into that. So first off, to file for divorce, a person can be married in the United States or outside of the United States, but it's required that both parties have lived in Illinois for 90 days. Illinois is thankfully a no-fault divorce state, which means that you don't need to show that any fault has occurred. It's nobody's fault except for irreconcilable differences as ground for a divorce. And there's a couple of different ways of showing that irreconcilable differences exist. One is that both parties live separately for 6 months immediately preceding the proceedings. So right before the proceedings, or must assert that there's been a breakdown in marriage and all reconciliation has failed. So it's a pretty low standard and relatively simple, but it is a court process that is important to have an attorney and to kind of understand going forward. Second, just a little bit about custody. In this state of Illinois, we don't use the term custody. We use the terms parenting time and parenting responsibilities. Parenting time is the physical time that you get to spend with your child. So overnight visits and calls or different things along those lines, holidays. Parenting responsibilities are making significant decisions about your child's schooling, about the religion, about different aspects, including health and other issues. To change a custody agreement, there must be an actual petition through the court. Typically, mediation is required, and the judges will look at the best interests of the child as the prevailing issue to figure out where would be the best placement for the child. And then, of course, overriding oftentimes can be an agreement. So it's always great when the parents have a plan and can work together to come up with the parenting style and parenting responsibilities plan. But all of this has to be ordered and has to go actually through the court system, through the domestic relations court. Third, to establish parentage, there's a couple of different options. The most standard one for folks would be that both parties are on the birth certificate, but sometimes that's not the case, and it's just one parent that is on the birth certificate. So if you would like to become to establish your paternity, whether it's your own paternity or another person's paternity, you can do a voluntary acknowledgement of paternity, which is a very simple form that both parties sign and submit to the domestic relations judge, and relatively simple. Otherwise, you can do a court hearing and do paternity/DNA tests. So those are the two standard ways of establishing paternity. Next, I'd like to give a little bit of time talking about child support. First of all, the first step would be to establish paternity if it's not already established. And then we have a very simple income shares model in the state of Illinois, and child support is always modifiable. So if there's been a change in employment, you can report that and it can be modified, or the change in the amount of time that a child is staying with different parents, that can be changed accordingly, but all through the court systems. And then, of course, child support will continue until the child actually reaches the age of 18 or graduates from high school. Next up, the child welfare system can be kind of confusing. There are a couple of ways that children can become DCFS involved, which is the Department of Children and Family Services. But if a child becomes DCFS involved, Illinois Department of Children and Family Services has a policy to not tell the federal government about the immigration status of the families it comes in contact with. So that's a really important barrier between the systems. Second, your immigration status alone is usually not a reason for a child to become system involved, but where a child might actually become child welfare system involved is if you are detained. And there was no one available to care for them when you were detained, or someone called Child Protective Hotline because they didn't know you were detained and they believed your children were abandoned, abused, or neglected, or someone called the Child Protection Hotline because they did not believe the person left to care for the children was providing adequate care to them. But anytime if your child is brought into the child welfare system, you should be giving a public defender that will represent your issues. I'm just going to go through these pretty quickly, just for the sake of time. There's also really important, it's important to understand domestic and gender-based violence issues. In Illinois, we have 3 civil orders of protection, which is abuse by a family or household member; civil no-contact orders, which involves sexual assault; stalking and no-contact order, which involves stalking or repeated harassment. To obtain one of these orders to protect you against abuse, this first step would be to file a petition for an emergency order of protection. It's an ex parte proceeding, which just means that the abuser or the perpetrator isn't present. And this OP, this emergency order of protection, is valid for just 21 days. So this next step would be, after those 21 days, there is an initial hearing. An initial court date will be held for a plenary. So a plenary is just a fancy word for just a more permanent order of protection, which would be for a maximum of 2 years in the state of Illinois. It's really important that the petitioner attend the second court date, because if they don't, unfortunately, the case will be dropped. If the petitioner, the person who's filing for the order of protection, is at that court date and the opposing party has been served and everything's going, you can ask the court for a default plenary order of protection, which would protect you. If you or someone you know has questions, they can reach out to CCH about filing this emergency order of protection. they can contact other illegal aid attorneys or go directly to the domestic violence help desk at the domestic violence courthouse at 555 West Harrison Street here in Chicago. If you're in other places, the system's slightly different, but the timing is essentially the same. So we wanted to spend a little time talking about public benefits assistance and appeals for immigrants in Illinois. So first off, healthcare. We're going to talk a little bit about healthcare. Illinois healthcare for immigrants and Medicaid are the two primary ways to receive healthcare. We're going to speak a little bit about TANF, which is the temporary assistance for needy families, SNAP, and how to apply. So for healthcare, there are a couple main programs. Illinois extended health benefits to immigrants 65 and older who are undocumented or documented. You have to have income below 100% federal poverty level, and there's formulas to figure that out online, and have assets below $17,500. To qualify for Medicaid, immigrants who are qualified non-citizens are generally eligible for coverage through Medicaid and the Children's Health Insurance Program, or CHIP, if they meet their state's income and residential rules. So the way you would qualify for Medicaid through qualified non-citizen is if you're a lawful permanent resident, asylees, refugees, Cuban, Haitian entrants, parole to the U.S. for at least 1 year, or a battered non-citizen spouse, or children of domestic violence situation. Next, there is Illinois has all kids Medicaid program for children up to the age of 19 years old. The income must be, to qualify, the family income must be under 318% of the federal poverty level. And it's available regardless of immigrant status, as long as the child is, quote, lawfully present in the U.S. And a resident of Illinois. So there's many different situations that go through that allow a person to qualify as a qualifying lawful immigrant present in the United States as a child. So if you would like to go on to the next slide, that would be great. And lastly, moms and babies, which covers healthcare for women while they're pregnant for up to 12 months after the baby is born. Moms and babies coverage is the full Medicaid benefit package, including and it covers both outpatient care and inpatient hospital care, including labor and delivery, primary and specialty care, and prescription drugs. And the income ceiling is 213% of the federal poverty level. And to qualify and to apply for those last two programs, all kids and moms and babies, you can call, you and or your client can call 1-866-ALL-KIDS, and that will get you to the right place to make that application. Next would be Supplemental Nutrition Assistance Program, which is income that's given to low-income household and a monthly amount of cash that they can be used for groceries. Many folks refer to this as food stamps. And to qualify, it's relatively low barrier. You must be qualified immigrants, so household total gross monthly income must be below 165% of the federal poverty level. And refugees and asylees who have had a hearing and have been granted asylum, parolees, and victims of human trafficking TE visa holders, Iraqi and Afghani immigrants who worked on behalf of the U.S., someone who has suffered extreme battering and cruelty by a spouse, parent, or by a member of the spouse or parent's family living in the same household, an adult with legal permanent resident status, aka a green card, or kids under the age of 18 who have a legal permanent residential status. Temporary assistance for needy families. You must have monthly grants to children and families. It helps families meet their basic needs, including rent, utilities, clothing, personal hygiene products, diapers, transportation, etc. Must be 30% of federal, make 30% of federal poverty level or less. And you can receive about $776 for a family of 5 in the state of Illinois. But there is unfortunately a time limit to 60 months. And there's typically a work requirement, which makes it difficult for many groups to be able to access this. But there are qualified immigrants groups that are able to access temporary assistance for needy families. So you can always reach out to us at facebook.com/Chicago Homeless, on our Twitter, Instagram, or website to find out more about our work. And if you'd like to move to the next slide. And of course, we always need a lot of help working with folks to make sure that people can actually access the education rights, their family law rights, or public benefits that they deserve. So if you're interested in volunteering or want to just know more about how you can get involved, please reach out to Alyssa Phillips or myself. Alyssa's email is aphillips@chicagohomeless.org, and mine is thomas@chicagohomeless.org. So we'd love to reach out to you to see if or for you to reach out to us to see how you can help us with our work. Next slide, please. And I think at this time, we're going to jump into some questions.
Awesome. Thanks, Thomas. So let's see. So just heads up, we might not know the answers to all these questions, but our hope is to guide you in the right direction. And if there's something that we can, investigate more, we can definitely try to reach out with those answers. So it looks like the first one is about work permits. So who CCH is referring individuals to in regards to work permits. I have not had anyone asking, since I'm mostly working with youth or students, about work permits. So I haven't been referring into one. Thomas, I don't know if you have any response to that.
I do not. But if you're interested and want to talk a little bit more offline, please. I'm not sure who sent this, but please feel free to email me, and then we can see if we can connect you with anybody or figure that out in another way.
Yeah. Let's see. It looks like, so I'd already talked about suburban school districts, but yes, they definitely have also been impacted. The same rights for students apply out there. And then looks like there's a question that says, we heard secondhand reports of schools requiring some proof of the adult being the parent or guardian for new arrivals because they said it was required as part of an anti-trafficking effort. So the federal law, McKinney-Vento, says that, right, you do not need a parent or guardian. So that law applies across school districts still. So if a youth is trying to apply and there's an adult caretaker who doesn't have guardianship, that student can be enrolled in school. So ISB is not and should not be requiring that, and school districts shouldn't be either. Now, if a school has concerns about, the adults or where the student is, that student should be enrolled in school. And then there should be steps to, connect that student with resources, connect them with social workers, with the liaison, with, the immigration services that are around, or whatever services would be useful and helpful to make sure that that student is safe. But the student should absolutely still be enrolled in school. And I think too, I even before kind of Illinois had this increase in newly arriving families, this was something I would get a lot of questions about at trainings is, what if there's a trafficking issue? But when you think about it, if a student is enrolled in school, they're connected around other adults. They're connected around people who are mandated reporters. They have a lot more access to resources and protections than if they were turned away from the school. They might not have any other kind of access to make sure that they were safe. So the federal law is that they can still be enrolled and should be. But if you are hearing this, please, reach out to us so that we can kind of figure out if this is happening and where to make sure that those students are, still being able to access school. And we will be sending out, there's a question about copies of the slide. We can all absolutely send that out to everyone who registered. So make sure that you were registered. And if you weren't, you could drop your email into the chat so we can make sure that that does get sent to you. There's another question. Do children have a right to ESL, to English Language Learning Services? Yes. So as I said at the beginning, children have a right to the same appropriate and free education. So if a child is in need of language services, they should absolutely be able to access those and have a right to those. And if the school district, every school district is different, every school is different. So, how they do that programming might be contracting with another school. So, I think the best thing is to make sure that's communicated to the liaison, to the school. But students should absolutely have access to any and all services they need to access, the same free, appropriate education. So the next question says, can a potential landlord refuse to rent to them because they have no credit rating or long-term income? If someone has a voucher, that will cover their rent for 6 months, but is having a hard time with a landlord. I don't know if Thomas, if you want to go for that one.
Yeah, I can touch upon this a tiny amount, but I think this might be something, and it's a little more case by case based on the length of the voucher, how much of the money is how much of the rent is covered. There is a source of income law or ordinance that was passed here in Chicago, which protects. We believe that it protects folks who are receiving vouchers. Unfortunately, I don't work in the area of housing that much, so I can't really get into the nitty gritty on this issue. But folks that are, I think, wrestling and with this issue right now, and may be able to help advise. Sorry, my headphones stopped working for a moment. Help advise a little more. And you can reach out to CCH directly, or whomever typed that question can email me at thomas@chicagohomeless.org for us to kind of continue the conversation.
Yeah, and I, similar to Thomas, I don't do a lot specifically around like landlord tenant issues, but I think always like a good piece of advice is, making sure someone is keeping records if they have, any emails or texts or things from a landlord, that they're keeping track of those, and then, reaching out. You can reach out to CCH if there's a local like tenant advocacy group around you as well around those questions, but making sure that, someone is keeping whatever documentation they have. It looks like the last question I think I see is, are there individuals sheltered at police stations that have not been processed as asylees that don't meet these qualifications? So I can answer around education, and maybe Thomas can answer around family law or around public benefits, but your immigration status does not matter for accessing education. Just across the board, it does not matter. So if a student is experiencing homelessness by staying at a police station, they don't have a permanent shelter, they are allowed to access school regardless of where they are in the process of seeking asylum, regardless of their immigration status. That has zero impact on their ability to access school and to be eligible as a McKinney-Vento student.
Yeah, thank you for that. And I think this question, I'm not sure exactly what time. It was pretty late, so I assume the question was around public benefits, but I'll hit upon the family law first really quickly, and then public benefits. For family law issues, as long as for the most part, as long as residency requirements were met, it shouldn't bar you from working within the family courts. If this was specifically around the wide variety of public benefits, it's complicated, and I'm going to give the most lawyer answer ever of it depends, because every single program, whether it's federal or state, have different qualifications and rules. And so I think it really just depends on the situation. And if you're not 100% sure, we have a really amazing public benefits specialist on our staff. Her name is Venus, and she is really great at working through these issues. And if I'm able to assist as well, I can assist as well. So I would definitely encourage you, or if it's you, or if it's someone you are working with, to reach out to us, and we can kind of try to answer those questions depending on the program that they're applying for. All right.
Yeah, so I think that is the questions we had. Like I said, here is both Thomas and I's email. So if there is something specific, please feel free to reach out. And I think, thank you so much for listening. We're really appreciative of this opportunity. And I think we know with, so many just new kind of issues happening in Chicago, and making sure that families have access to services and rights they need. Always feel free to reach out if there are questions or concerns. If you hear someone being turned away from something and it doesn't feel right, please reach out. Even if, it's just a question, we're more than happy to kind of think through that.
All right. Yeah. Thank you so much. Y'all have a great rest of your day, and thank you for attending. If you're an attorney, we'll be sending out your survey later today. And then if you're someone else who would just like access to the slides, we'll send the slides out to everyone who is registered. But if you weren't registered, or you know somebody that needs it, please just email us and we can send the slides to you. Thank you so much.
Thank you.